Hi, it's Christine Scudder back here, talking with you about some of our more vulnerable populations that we serve in our public schools. This is not going to be exhaustive, but definitely want to highlight, a couple of groups of students who are at high risk of not graduating and or experiencing harm in our public school system. So I want to first start by talking about homeless children and youth, and not surprisingly, it's hard for us to have really accurate numbers as the term homelessness or, housing insecure, these terms can be used interchangeably. There's a lot of shame that can be involved in people identifying as being homeless. And so, it's with these caveats that we understand and often kind of understand that these numbers are probably a lot higher than what I'm sharing here. That said, what we do know from the U.S. Department of Housing and Urban Development is that 16% of California's homeless population are families. And when we talk about young people who are homeless, oftentimes that only counts teenagers. And sometimes the age range of teens can vary by study, so that data can also get a little murky. But that said, at least 21,000 families here in California are considered homeless. When we think about our student population in K-12 schools in California, we know that statewide 4.4% of our K-12 student population are considered homeless. And if you look through, and the source here is Kids Data or kidsdata.org. If you're not familiar with that resource, it's a really good one, and I have a link to it on B-Courses. If you're looking for current data from our state specific to children, it's a great place to look if you're writing grants or if you are in need of this kind of data. It's a good source. And as you look through that, they have the data, the homeless student population divided by county across the state. And what you see is that in some areas, the student population that's considered homeless is as high as 20%, and the lowest would be 1.1% in the state. I've just highlighted a couple of the counties in the Bay Area here for you to consider. As you can see, the highest rate among some of our local Bay Area counties is San Francisco County at 4.2% of the student population considered homeless, followed by Marin County at 3.7%. So again, this is a population of young people who are definitely at risk of not getting to school and not completing their K-12 education. Homeless children with just some more specificity to the stats are 9 times more likely to repeat a grade, 4 times more likely to drop out of school, 3 times more likely to be placed in special education than their securely housed peers. So this is important for us to think about as we consider the needs of this population. You may be familiar with the McKinney-Vento Homelessness Assistance Act of 1987. More often people just call it McKinney-Vento. And this is a federal law for homeless children to ensure stability. The image on the right is a poster that, or the annual version of it. They change it every year or every couple of years, but has the general information about families' rights to enroll their children in school, even if they are homeless. Under the law, it defines homeless youth as persons who lack fixed, regular, and adequate nighttime residence. So this allows students to remain in the same school that they were in before becoming homeless, even if they're temporarily housed in a different district. So for example, if a child or family is living in a homeless shelter or in temporary housing, like a motel, for example, or living with friends, they can still go to their same school. In some cases, I used to work at a domestic violence shelter. In some cases, it was not safe for children to return to their school of origin because there may be a family member who is looking for their parent, stalking or other other situations relating to family violence. And, but McKinney-Vento was helpful to those kiddos in terms of making sure, for example, that they had free transportation to and from school, right? But regardless, there are some other key benefits that people have the rights to in terms of free school meals, access to a full range of extracurricular activities, and the like. So students who fall under McKinney-Vento, their status needs to be reviewed annually. Each school district should have a homeless or McKinney-Vento liaison. They might be called something different. Oftentimes the person who holds this role wears a lot of different hats. And so as social workers, it's really important for us to know who that person is in the school district so that we can help our youth and families to access needed services. I'm going to switch to talking a little bit about foster youth, and also foster youth are sometimes among the youth who are homeless. So I don't want to suggest that these groups are mutually exclusive. Here in California, we have more than 74,000 children in foster care. Those are pretty staggering numbers just for our state alone. Foster youth are overrepresented at almost 3 times the national average in special education, whereas about 15% of U.S. children generally repeat grades at some point in their K-12 experience. 23% of foster youth repeat grades. Approximately 50% of foster youth are held back a grade at least once, so half, right? That's a lot of kids getting held back. Another important thing for us to keep in mind is that every time a foster youth changes placements, and when I use the word placement, I mean that they are moving, okay? So if they move from one foster home to another, if they move into or out of a group home, while we're trying to eliminate excessive use of congregate care or group home care here in the state of California. We still do have congregate care, but regardless, a placement is whether it's considered a place like that or in a more of a quote family setting. So every time a foster youth moves, a switch can cost them up to 6 months of learning time, right? Because they have to get caught up, reacclimated. This is a really devastating loss to their educational trajectory. Approximately 10 to 15% of foster youth in California have 3 or more placements while in care. Okay, so for that 10 to 15%, they are losing up to 18 months of learning time. So this is a really critical issue for our young people in foster care. And over a third of foster youth in California are suspended or expelled at least once. Okay, and this is at 3 times the rate of children who live with their biological families. So again, these youth are more often coming to the attention of special education, discipline, retention, and again, lots of loss of learning time. So there have been a lot of powerful advocacy groups, current and former foster youth, social workers, and other allied folks have come together over the past 15 years or so to really put forward a powerful compendium of public policies that are in place to support our foster youth in education. So I'm going to highlight a couple of those. One of the first was AB 490. It came out in 2004. This bill was really powerful in terms of allowing foster youth to stay in their school of origin when it was considered in their best interest. This helps because sometimes foster youth, it's not uncommon, for example, for foster youth to have to move quite far away from one placement to the next. For example, housing in San Francisco is at a premium, so it's not uncommon for foster youth if they're brought into care, they may have to be placed way out in Antioch or Bay Point or somewhere very far away from where they were living previously. And this can be really disruptive, especially for kiddos who may be in high school and middle school, which is not to say it's not devastating in elementary school, but, when they're a little bit older and, they may be able to have a little bit more agency to get to their school. This may make more sense for really young kids to have to travel, a couple of hours to get back to their school of origin. May not be considered in their best interest, and it may, right? But it's important to know that with this law, it's an option for foster youth. foster youth are also afforded immediate enrollment without the normally required documents like a birth certificate, proof of residence, immunization records. This was often a huge barrier. By the time, youth would be moved maybe in the middle of the night and, would have to wait for days until they were able to get their documentation back so that they could enroll in school. So this is a huge benefit that kind of brings parity to McKinney-Vento if you think about it in that way. Student records need to be requested and forwarded between schools within 2 days. This is another huge piece where foster youth were losing access to continuity of education because, for example, their CUME files, IEPs, things like this were just getting lost and backlogged between districts. So these records have to be requested and forwarded within 2 days. Foster youth also have a right to partial credits. So if they leave in the middle of a term, the receiving district needs to consider granting partial credits, and they do have a right to that. So the districts have to err on the side of giving credit to foster youth for work that they had completed. So these are all, in part to help to mitigate some of those problems that I mentioned in an earlier slide. Another pair of bills, AB 167 and AB 216 in 2009 and 2013 respectively, really looked at exempting foster youth, from local graduation requirements. Specifically 11th and 12th graders who were in foster care and or on probation who had to change schools were able to meet reduced graduation requirements, because what would happen is that sometimes, between districts will set their own graduation requirements. They may have more credits than the minimum, for example, to graduate. And so sometimes foster youth would be right on track to be graduating in one district and then move to another where they were then considered very far behind. So this allowed them to, of the two, for example, if they moved to a place with higher requirements, that they would be able to retain the requirements that they came from, or vice versa. However, students, when we still had the CASE, the California High School Exit Exam, under these laws, which were passed prior to when the CASE was suspended on January 1st, 2016. So as of this recording, we are not using the CASE. But as of that time, the legislation stated that they would still have to pass the CASE unless they were eligible for special education waivers. And the new school had 30 days upon receiving a student transfer to determine if the foster youth was eligible to graduate. So as opposed to kind of having them wait in limbo. So you'll see a lot of these bills have a lot of kind of attention paid to the amount of time that systems have to respond, because foster youth were often languishing in the system, in the education systems, and other systems as well, mental health and others. But these, again, are focused on ed policy to really make sure that we're being accountable to foster youth and responding in a timely manner. AB 81 in 2009 had to do with extracurricular activities. And this may sound like a small thing, but I think it's important, to know that school districts have a lot of pretty rigorous policies in place for things like sports teams, and it's just one example of an extracurricular. But school districts do try to be mindful of making sure that they have really clear guidelines so that kids don't district hop just to get into a better sports team, or kind of set forward their own advantages related to that. AB 81 really looks to address this to make sure that foster youth would be an exception to that, to a lot of those kinds of rules and guidelines. So the foster youth would have access to all extracurricular and enrichment activities when they change districts, that they would automatically meet activity requirements. There might be, for example, a residency requirement, or, would have to be in a district for a year before they'd be eligible to try out for varsity or something like that. So in AB 81, it really looks at that automatic requirement. Prohibits any other law from preventing foster youth from participating in said activities. So again, you see this kind of forward thinking and trying to mitigate other barriers. when we think about public policy, points like this third one here really have a lot to do with kind of helping us think about the issue of implementation. We often talk about, passing laws is one thing, but implementation is where the real work begins. And sometimes you'll see laws written in such a way, or bills written in such a way that when they become law, they also take into account future laws that could get in their way, right? So this is a good example of that. AB 81 also looks at requiring private agencies that provide foster care to have policies to promote participation in extracurricular activities. This is an important area for us to know about. Again, as social workers, it may come to your attention that you have a foster youth who is moving into your district, to your school, and so it's important for us to know these policies and, not necessarily to memorize that it's AB 81, right? But hopefully you'll remember, this information and be able to go back and find it if the school district were to say, no, this student doesn't qualify, they need to wait a year, what have you. So AB 12, which folks may have heard about if you've been working with youth or youth in the child welfare system. AB 12 passed in the year 2010, and subsequent bills increased access, which I'll talk about. But in AB 12, when it was first passed, established this category of children under the juvenile court system, non-minor dependents, meaning they were over the age of 21, but they'd be allowed to remain in foster care until the age of 19. As you see that asterisk, subsequent bills increase that access to the age of 21. Okay, so 6 months prior to turning 18, social workers in the child welfare system, CPS workers who are working with this population, need to work with their youth to come up with a plan if they would like to become non-minor dependents. It is not an automatic. They do need to both want it and also be able to meet certain criteria. And that criteria includes meeting at least one of the following: completing high school or an equivalency program, like a GED. They have to enroll in college, community college, or vocational education, be employed a minimum of 80 hours a month, participate in a program to promote or remove barriers to employment. That might include something like mental health services, for example. Or because of a medical condition, they're unable to complete the tasks listed above. So this could be medical, primary, like organic medical condition. This could also be a mental health condition. So again, a minor would need to be working on at least one of these in order to meet criteria for eligibility for AB 12 services. This is a really powerful law. When it became law in 2010, AB 12 really served to increase our care for this population of transition age youth, right? A lot of times foster youth's connections to their biological family and other natural supports have been severed and or compromised, either because of the original abuse or neglect that brought them into the system in the first place, and or because of the repeated disruptions that they experienced from having multiple places that they had to live over a period of time, that they really didn't have that safety net that a lot of children have, a lot of young people have. And so AB 12 really recognizes that piece, and education has an important part of that. So I want to talk a little bit about transgender, gender nonconforming students as another very vulnerable population. So I want to just talk for a quick minute about this umbrella. I think sometimes people use the alphabet soup, if you will, kind of interchangeably, and people talk about the LGBT community and put the LGB and the T all together. We certainly see this, quite often with a lot of human rights groups and queer rights agencies and organizations. But it's important to remember that lesbian, gay, and bisexual refers to sexual orientation, where transgender refers to gender identity. And so I want to talk specifically about supports and protections for trans and gender nonconforming students in particular, though I will reference a couple of points that are specific to LGBT students as we go forward in this. This has been a very big area of policy change. We've seen the pendulum go back and forth really rapidly with this in recent years. So let's get into some of that now. So I want to just step back and briefly acknowledge some of the differences between some of the terms I'm going to use. One is the term executive order. An executive order is issued by the U.S. President. These are directives that have the force of law. Like laws generated in the legislative branch, they are subject to judicial review. What that means is that the judicial branch, right, we talked about the three branches of government, the judicial branch provides checks and balances to laws that come about in order to basically test them if they're legal or not, right? So if an executive order is issued that is viewed to be illegal due to other existing law that's on the books, the judicial branch can come into a case can be brought forward through the judicial branch to have that be reviewed. And so you definitely hear a lot about executive orders. There was a lot of conversation and controversy when President Obama was issuing executive orders in terms of trying to address areas of immigration law. Toward the end of his presidency in particular, there's definitely a lot of back and forth and conversation about whether or not President Trump is going to issue executive orders. So that's something I just wanted to acknowledge it. I'm not going to talk too much more about it, but to just differentiate it from other forms of guidance and law. Another important area for us is case law. In case law, again, these are decisions that come forward from the judicial branch, and when issued at the Supreme Court level, as we talked about in an earlier lecture, those case law decisions impact the entire United States. Sometimes you will have legal decisions that only cover certain states. For example, Ninth Circuit court decisions, federal court decisions would cover the state of California. Supreme Court decisions would cover California and the rest of the United States. Important examples of case law when we think of the school system include Brown versus Board of Education, right? Is an important example of case law that establishes that separate is never equal. Okay, and that's an important piece for us to keep in mind. So executive orders come from the executive branch. Of course, legislative policies come from the legislative branch. I was just giving you examples of AB and SB, right? Assembly bill, Senate bill. Those come through the legislative branch, right? So executive, legislative, and judicial. Then I'm going to talk about this last category here, for now anyway. This is called guidance. And guidance is just that. It's guidance. It can take a very important, it's a very important point of reference, particularly when issued at the federal level, can also be issued at the state level. And guidance really is offered to help folks who fall under their guidance. So at the federal level, that would apply to the entire country. At state levels, if it was state guidance, it would apply just to us in California if issued here. Guidance really helps folks to kind of translate, if you will, information that's on the books. And as we're talking about trans and gender nonconforming students in particular here, there have been recent areas of guidance that have been issued in terms of helping school districts to be really crystal clear about how the federal government, for example, in particular, is looking at issues of sex and discrimination, sex discrimination. So guidance is not an executive order, and it's also not case law. It's also not a legislative type of policy. It's within the executive branch, but again, it's meant to kind of, if you will, color in the lines of things that may not be explicitly clear. The Supreme Court, for example, has definitely dodged the question of really trying to clarify how the country is going to make sense of protections for transgender people in healthcare, in employment, in education, just to name a few areas. And so when we don't have clear federal policies in the law, which we'll talk about that we do not currently to protect trans and gender nonconforming folks, we're kind of left with trying to make sense based on case law and guidance most often, and that's really what we see a lot of at this point. So under the Obama administration in 2016, you'll often hear when talking about the rights of trans and gender nonconforming students, you'll hear people talk about a Dear Colleague letter. I want to be really clear that Dear Colleague letters are issued somewhat regularly, and so you may hear this term used elsewhere, and it may not be about this population. So I just want to be clear about that. But to clarify, a letter was issued jointly under the Obama administration in 2016. It was issued by the Civil Rights Division of the Department of Justice and Department of Education, and it focused on transgender students. And I put a copy of that letter on B Courses. It is currently considered archived, meaning that it does not carry the current force of the Civil Rights Department of the Department of Justice and Department of Education, which we'll talk about. However, it is a very important document. As we'll talk about, you'll see how it's been referenced in both court decisions as well as state legislative decisions in recent years. One of the very first things Trump came into office towards the end of January 2017, and by February had issued a rescindance of this guidance from the Dear Colleague letter, citing that there was uneven legal precedent, no formal public process for defining the term sex. And so this quickly rescinded the Dear Colleague letter that had really been viewed as a huge boon for trans students and gender nonconforming students' rights in schools. And so this was a pretty big step, definitely symbolic, right? Because again, guidance is not law, but it definitely helps people make sense of the law. I have posted on B Courses a copy of a conference call and a webinar that was co-hosted by the Transgender Law Center and other folks really soon after Trump issued this rescinded this guidance rather, to really be clear that it didn't mean that it wasn't really changing anything, but it certainly sent a very clear signal, which wasn't surprising, given in particular Vice President Pence's stance on LGBTQ rights and his thoughts on protections for these groups. So this is an important part of the recent history and policy. So when we talk about protections for under sex and where trans and gender nonconforming students have been able to wage important court battles to help make room for rights has really been on under Title IX. Title IX of the Education Amendments of 1972 is its formal name. And this is comprehensive federal law that prohibits discrimination on the basis of sex in any federally funded education program or activity. Okay, so because public education includes federal funding, that includes all of our public K-12 educational programs. Okay, so Title IX, Title IX did not explicitly state protection for gender identity or gender nonconforming individuals, and this is where guidance letters came into play, right? It does talk specifically about prohibiting discrimination on the basis of sex. So this has really become a key battle, is how is sex defined? So the United States Department of Health and Human Services, we've seen in very recent periods, up to and including a couple of days ago, as of this recording in May 2019. So in 2016, the U.S. Department of Health and Human Services issued a rule that defined discrimination on the basis of sex to include termination of pregnancy and gender identity, which was defined as one's internal sense of being male, female, neither, or a combination of both male and female. Okay, so this was definitely viewed, while it could certainly have gone further, it was definitely viewed as a major step forward in supporting protections and offering a clear legal basis for folks to wage lawsuits if need be in protecting the rights of gender nonconforming trans students and adults, depending on the system, but here we're talking about education and K-12. So this was a big deal, and this new rule was, as you can see, in alignment with what I was talking about from the Dear Colleague letter that was issued through the Departments of Justice and Education. So you start seeing the different federal departments kind of aligning, right? Justice, Education, Health and Human Services, all coming together to say something similar. It was really important. Then in 2018, there was a leaked memo, this is now under the Trump administration, that reflected that there were some efforts underway to establish the definition of sex under Title IX to be as such. Sex means a person's status as male or female based on immutable biological traits, identifiable by or before birth. The sex listed on a person's birth certificate, as originally issued, shall constitute definitive proof of a person's sex unless rebuttable by reliable genetic evidence. So you see here a huge shift, pendulum shift the other direction under the Trump administration. Now, again, this was a leaked memo. This did not carry the force of the department, but it certainly was a signal of things to come. And so we have just another one of several recent points that are pointing towards the fact that the federal government is taking increasing steps. So as of several days ago, here at the end of May, there is a proposal by the U.S. Department of Health and Human Services to revise the Affordable Care Act, or ACA. Some people refer to it as Obamacare, where it states, when Congress prohibited sex discrimination, it did so to the plain meaning of the term, and we are making our regulations conform. And so according to the plain meaning of the term, kind of back to this kind of immutable biological trait definition, not this notion of gender identity. So, the construct of the terminology of gender identity was certainly not part of the lexicon of the 1970s. And so there is some back and forth debate in policy that is very much underway to look at taking us back a bit, because there were definite major gains that came forward under the Obama administration, which, are still very hopeful in terms of protecting the rights of trans and gender nonconforming folks, both young people and adults, which we'll talk about. So, there are a number of federal laws and policies that have gone into effect in recent years. The Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act is a federal legislation that has to do with defining hate crimes on the basis of sexual orientation. Don't ask, don't tell, policy of the U.S. military that came into being under President Clinton was repealed in 2011. So these are some federal laws and policies, but it's really important to understand that federal protections against discrimination explicitly for LGBT and or T folks are still not yet law. Okay, so we have pending the Employment Non-Discrimination Act, the Student Non-Discrimination Act, and Safe Schools Improvement Act. These are some examples of federal laws that at different points have had varying amounts of bipartisan support over the years to try to really be explicit and be very clear that the civil rights gains of the 1970s is meant to include explicitly, not implicitly, but explicitly lesbian, gay, bisexual, transgender / gender nonconforming people. Absent these federal laws, what we find is, if you will, a patchwork quilt of laws and policies across the United States. We are here in the state of California, where there are some very strong state level laws and policies in place. It's important to understand that that state laws can certainly be more stringent than what the federal law requires. It can be difficult if state and federal law are at odds with one another, right? As we'd seen for a number of years, for example, with the legalization of marijuana, right? It's different state levels when federally, we still are in this situation where marijuana is considered an illegal substance at the federal level, right? So when there's a discrepancy between state and federal law, sometimes that can be very complicated. But, as social workers, also it's important for us to understand not just, what's happening to, quote, our clients, in our, quote, area, right, if we're here and practicing in California. So I do want to make sure to mention both kind of what's happening around the country as well as here in the state. So the whole bathroom bill debate is definitely something that, was a firestorm that started. One might argue, and some have argued, that it really took hold after California passed AB 1266 in 2013. Here is the first state to give transgender K-12 students the choice of restroom and locker room facilities that match with their gender identity, and were not limited to having to match their gender assigned to them at birth. So this definitely, there was a lot of news articles at the time. There was a lot of backlash across the country, and we started to see this happen very quickly. So soon thereafter, we started seeing quote-unquote bathroom bills for both school and public restrooms in states like Nevada, Florida, Kentucky, Texas, Tennessee, South Dakota, and one of the more famous ones in North Carolina. House Bill 2 that, they took forward and passed in, I think, under 2 hours. Took a bill all the way through the process to pass it into law. So we saw, a lot of very quick movement, a lot of very powerful movement and backlash in this area to, quote, protect students' safety in schools. And so I think the question we always want to keep asking too is who's being harmed and whose safety is really being protected. So, as I mentioned at the beginning of this section, it's important to remember that while the LGBT umbrella is often invoked and kind of bringing all of those letters together and those groups by association together, we don't always see that all students under that umbrella are treated equally. So, states that do include harassment and bullying in schools are not always LGBT inclusive. 20 states plus the District of Columbia do address bullying for LGBT students in particular, and that includes us here in California. 5 states prohibit bullying on the basis of sexual orientation, but are silent on the issue of bullying on the basis of gender identity. 2 states prevent districts from specifically protecting LGBT students, South Dakota and Missouri. So what that means is that there is a law in place stating that you can't protect LGBT students, which is so distressing. There are 8 states that restrict inclusions of LGBT topics in schools, and you see those states listed. Okay, so you can't even talk about LGBT-related topics, which, of course, then can make it very difficult for any student to come forward and articulate any kind of bullying that might be happening because of their identity that may be related to identifying as LGBT or being perceived to be lesbian, gay, bisexual, or transgender. So when we talk about safe school laws, we also continue to see that patchwork. We have 8 states that have what are called don't say gay laws. They're often vague in their language, but they do forbid the discussion of same-sex relationships and sex education. And they're also often used to ban the recognition in other parts of the curriculum, even acknowledging that an author was gay, for example, or allowing queer alliance groups or LGBT related groups on campus in schools. So you see the list of states there. 12 states plus the District of Columbia have laws prohibiting discrimination in schools on the basis of sexual orientation and gender identity. So this is important. This includes California. So that's, it's 12 states plus DC. That's not a whole lot of states yet, but it prohibits discrimination. It's important to understand that anti-discrimination laws federally do not currently include sexual orientation and gender identity. And so it really is up to the states to do that kind of work, both in employment, in schools, in healthcare, etc. Okay, so it's clear for us to understand that this is covered in schools in this state. 33 states have no laws protecting LGBT students against discrimination. So when we talk about what it means to support LGBT students in California, Seth's law is an important law that went into effect, that was originally written under as SB 9, went into effect in July 2012 and is codified into the California Education Code as specified there. So Seth's law requires public schools to update anti-bullying policies to protect students bullied based on actual or perceived sexual orientation, gender identity, gender expression, as well as race, ethnicity, nationality, gender, disability, and religion. So it's important to note that this bill includes actual or perceived. This is considered very progressive language, because it covers students who may or may not identify this way, but may be being bullied because of a perception that they do or that they are. So it means that students do not have to come out in order to be protected, and students do not have to share anything about how they identify themselves, which is really important. And this is sad that it has to be included in the policy, but it is a reality that you will hear time and again from young people in surveys about being bullied and harmed in schools because of their identity. The teachers knew about it and didn't do anything. They heard it, or they were standing right there. They laughed. They looked at me and they turned away. All these kinds of quotes that teachers and faculty knew. And often may, have felt awkward about it, or they may have agreed with the sentiments of the bullies. There's any number of different ways to interpret that. But time and again, young people have really felt that school personnel have really walked away when they could have taken a stand. And so Seth's law explicitly states that school personnel must intervene. And so that needs to be documented. How school personnel respond. So this is important for us to know as social workers in terms of addressing issues of school climate, for example, when issues are brought to our attention, as one example. So, I mentioned earlier case law as being important, and I just want to briefly touch on a couple of important cases that have been coming forward through the courts in the last couple of years. There's definitely been more kind of signaling that the Supreme Court may need to try to weigh in on this issue of trans and gender nonconforming student rights in schools as related to being able to use bathrooms and locker rooms that are consistent with their gender identity and which do not place them separately and apart from their peers. So Gavin Grimm, but in the court case was known as GG versus Gloucester County, Virginia School Board in 2016. Virginia is in the 4th Circuit. Again, California's in the 9th Circuit, Virginia's in the 4th. So this case went to the 4th Circuit Court of Appeals in May of 2016. Gavin is a trans high school student, trans male, who's using the boys' restroom. That was in keeping with their gender identity. At first, the school was fine with it, but as a few parents actually complained to the school. It wasn't students, but parents complained, and so the student was no longer allowed to use the boys' restroom. Gavin was offered a bathroom in the nurse's office, so Gavin would have to go, far from his classes to find the nurse's restroom. He was the only student that used that restroom, and so it definitely outed Gavin, and this is while this case was specific to his experience, this is definitely a strategy that a lot of schools have used in terms of trying to get around having to kind of take a stand like California took with AB 1266, but also try to be in compliance with the Dear Colleague letter. You started to see a lot of schools trying to have students use a special restroom or the staff restroom. But, looking at how the courts were holding this under Title IX, prohibiting discrimination on the basis of sex in any federally funded education program or activity, the idea was that Gavin was being discriminated against because of his gender identity, which is on the basis of sex, and was having to use a restroom that was different than all of the other students who did not well, first of all the other students in the school, and because of his gender identity. So the case actually went up to this U.S. Supreme Court, but following the Trump decision relating to rescinding the guidance that I mentioned earlier, they returned it to the lower court, and the lower court looked at both Title IX and the U.S. Constitution as protecting trans students from being excluded from common restrooms that align with their gender identity. So this did did happen at the lower court level. We almost got a Supreme Court decision, but it did not go there. And so, it does look like even in the Trump era, as I mentioned in the webinar that they talked about through the Transgender Law Center, the changes that have happened under the Trump administration may or may not actually impact the gains that have been made. It certainly calls a lot into question, and you see the U.S. Supreme Court saying, not so sure what we should do here. And so there's a lot of pressure to kind of, quote, leave it to the states, and again, to happen at the lower level. Another really important court decision, Whitaker v. Kenosha Unified School District. Ash Whitaker is a trans boy, 16-year-old, after using a male-designated restroom at the high school, was told they cannot do so any longer, also given a key for a separate individual restroom. And so there was also a proposal by the district that all trans students would wear bright green wristbands to monitor restroom use, right? So they would be issued a wristband so that they would know who should be using which restroom. This went to the 7th Circuit Court of Appeals in a unanimous decision that trans students are protected from sex discrimination under Title IX. So this was another important win. Again, having it be unanimous is important, and having these case law decisions that state that sex discrimination, that trans students are protected from sex discrimination under Title IX, and linking those two together, where Title IX does not explicitly state gender identity, but the courts are basically, when case law is saying, hey, these case decisions take the form of case law and say, hey, we are bringing these two things together. We are saying that this is how the court views the importance of protections, right? So then if we have students who have cases in other courts, right? So the 7th Circuit, the 7th Circuit, those are places where this has been brought to appeal. If we have it happen in all the circuits, that could take the effect of a Supreme Court decision, for example, right? The U.S. Supreme Court will ultimately settle it as the law of the land. There's some hesitation, given the current makeup of the Supreme Court, to have a case go back before it. So there's, kind of a lot up in the air related to this topic. I want to talk a bit about another population of vulnerable students in the state of California who are English language learners. When people talk about education in California, one of the challenges that's often cited is the sheer number of English language learners in the state. Sometimes pundits will refer to this as a burden of the state, and other folks will talk about this as one of our greatest gifts in the state of California, is our rich diversity among students and families and communities that we serve. So I want to take a look at some of the numbers and talk about some of the ways that these students can be and have been at risk, and some of the policies in place to protect them. So currently, almost 1.2 million students in our public schools in California are considered English language learners. That represents 19.3% of the total school enrollment in the state. 41.8% of students speak a language other than English in their homes, right? So that doesn't, they may be bi or trilingual. 70.2% of English language learners in the state are enrolled in K-6 education, and 29.8% are enrolled in grades 6 through 12. Okay, so we see almost 3/4 of our English language learners are in our younger schools, K-6, at least currently, as of 2019, according to the California Department of Education. So it's important for us to think about laws and policies as they pertain to, quote, English proficiency. This has been another hotbed area of discrimination and of white supremacy that has, certainly been present throughout history in the public education system. I want to talk about some of the more recent decisions. One important one is a Supreme Court decision, Lau v. Nichols in 1974. This was, as I mentioned in an earlier lecture, I think it was the last week's lecture, or last time, I showed you a picture of some of our students in San Francisco. So this court decision, Supreme Court decision, was a result of Chinese students in San Francisco who sued for not having enough resources in the school district to help with low English proficiency because they were English language learners. And so Lau v. Nichols reaffirms the rights of non-English speakers to be free from discrimination in education, including having adequate materials to facilitate their learning in their language, their native language, and also supporting English language development. We have numerous laws on the books. One example is a 91-year-old English-only law that was in existence in Hawaii until 1987. So when this law was on the books for nearly 100 years, it did not allow any indigenous language, indigenous Hawaiian languages to be spoken in public schools. It was English only. In 1990, we have the Native American Language Act that declared Native Americans have the right to use their own languages in public schools. And it was amended in 1992 and further to preserve, protect, and promote the rights and freedoms of Native Americans to use and develop their own indigenous languages. Now, it's very devastating, as we talked about, the painful legacy of the Indian boarding schools that really removed Native and Indigenous children from their families and communities and their language. And so it's very sad to have a law so recently put on the books to affirm the rights of a people to be able to use their own language. And that's an important thing to acknowledge here as well. I mentioned in an earlier lecture the ways in which the state of California has used propositions to settle and address really important issues, everything from same-sex marriage to bilingual education. And Prop 227 in 1998 was also called the English Language in Public Schools Statute, or English for Children Initiative in California. And it was really presented, it's always important to look at the ways in which propositions are written and kind of how they're marketed versus what they actually say. And they were presented, this proposition was presented as something to improve English language instruction for children who need to learn English for economic reasons. But what it really did was it really slashed bilingual education in California. Within 2 years after it passed, bilingual education in the state was slashed by over 50%. So we saw a dramatic decrease in bilingual education in the state. Subsequently, it was important in 2016, Proposition 58, or the California non-English languages allowed in public education, repealed most of 227. So it took quite a number of years, almost 20 years later, to repeal Prop 227. It required school districts to solicit parent and community input in developing language acquisition programs, required instruction to ensure English acquisition as rapidly and effectively as possible, authorizes, not dissuades, but actually authorizes school districts to establish dual language immersion programs for both native and non-native English speakers. So this drastically changed the landscape once again. And we see that current laws and policies are in place in the state that reflect Prop 58. So when we talk about English learners in the state of California in 2019, Although we've got about 67 different language groups in the state, at least when asked, that's what we have in terms of data. 93% of folks who are English learners in the state speak one of the top 10 languages that are listed here. And as you can see, Spanish is far and away the top language at 81.56% of English learners in the state speak Spanish, followed by Vietnamese, Mandarin, Arabic, Filipino, Cantonese, as in Korean, Punjabi, Russian, and Hmong. So, this is important for us to know when we think about what are the languages that we need, and what you'll see in certain in areas and districts are what are called threshold languages. And threshold languages are those that, may be prevalent in the immediate community. For example, while you can see on this slide that Russian is only 0.76% of the English learner population in the state, in certain parts of the state, for example, in San Francisco, Russian is considered a threshold language. And so you will see items more readily translated into Russian and posted as such, right? And so it's important for us to understand what those threshold languages are as social workers in the districts that we might work in. So our current education policy really reflects, what Prop 58 brought to bear, right? So our current policy in the state is that English learners acquire full proficiency in English as rapidly and effectively as possible, as I said, and attain parity with native speakers of English in terms of their abilities with all subjects, and then ensure that English learners within a reasonable period of time achieve the same rigorous grade level academic standards that are expected of all students. So within a reasonable period of time is not fully defined, and as we'll see from looking at test data, we will see that we'll see the ways in which English learners may struggle, not surprisingly, with standardized tests that are provided in English. And some people who have been very critical of the challenges of providing education in the state of California with the sheer numbers of folks who are English learners in the state, that quote unquote ruins our test scores in California. You'll hear that sometimes used in policy debates, which of course is hugely problematic and discriminatory. And it's important for us as social workers to really be thinking about how we may respond to that kind of criticism. If you're interested in looking specifically at how the Education Code defines how English language development instruction is designed, ELD in California, we have specific definitions of dual language immersion, transitional or developmental programs, and structured English immersion. That helps to kind of define in a bit more clarity. It's not quite, it doesn't quite define reasonable period of time, but it does really kind of unpack the speed with which and the means by which language is addressed in our educational system. That's more of a role for teachers, but I do point it out to you as social workers so that you know you may be working with newcomers, or you may be working with families who have children who are English learners and want to have more information about the different opportunities for language development in the state. I want to talk about a very vulnerable population of students, undocumented students. We are at a very critical and sobering moment in the politics of this country at this time. And this is a group of students who is at high risk for many different interventions. And so it's important that we understand well what may protect students who are undocumented and ways in which both federal law, state law, and case law may or may not protect our students. So under the U.S. Constitution, there are certain rights that are afforded to all persons that are in this country. Under the Fourth Amendment of the U.S. Constitution, there's protection against unreasonable search and seizure. and this is important for us to know in other areas of ed policy, but as it pertains specifically to undocumented students, students are protected from that unreasonable search and seizure on school property. It is important to know that there are these border search exceptions that exist within 100 miles of U.S. borders where such searches are considered lawful. So for our border areas in the state, this is important for us to know, but there are Fourth Amendment protections. Under the Fifth Amendment, our undocumented students, like all people in this country, have the right to due process. And so, due process under the law, it's important to understand, however, that this threshold is usually far lower in immigration cases. Immigration courts are less clearly governed by constitutional protections. This is an area of the law that can be quite fuzzy as it pertains to immigration courts in particular. But when we look at issues of due process in general, the right to know what you're being accused of, your right to face your accuser, those rights are in place. But for example, the right to an attorney, that is a right that is afforded to a person in a criminal case, but not in a civil case. And as we'll talk about that in a moment. Which gets into the Sixth Amendment, as I said. So the right to legal counsel in criminal cases. So it's important to understand that immigration-related legal cases are considered civil. They're considered actually administrative issues that are handled in civil court. They are not criminal court. And so you have the right to an attorney if you have a criminal case, but immigration cases are civil cases. And this is a little outside the specific and kind of more narrow focus of this particular class, but just to be really clear, when you think about the ways in which people are locked up, and basically, if you look at immigration holding areas, look like prisons. People are held in cages and are not afforded an attorney unless they have one that, a pro bono attorney or someone knows about their case. This is important to understand that our immigration courts are maybe working with people who are treated like they are criminals, but under U.S. law, these issues are held in immigration courts that run more like civil court systems. This is a really important part. The 14th Amendment offers equal protection, the Equal Protection Clause, equal protection under the law. And one of the most important court decisions, if you remember nothing else about case law or policies, when you talk about the rights of our undocumented students, this is a case you must know. It is Plyler v. Doe. It was a Supreme Court decision in 1982 that provides equal protection under the law to our undocumented students who have a right to go to school through K-12 education. Okay. Plyler v. Doe is a huge part of the linchpin of what protects our undocumented students in our public schools right now. It's important to understand it, and it is certainly under some discussion, which I'll get to in just a moment. So please do remember and make note of Plyler v. Doe. I've posted some additional information on B courses if you'd like to read more about it and how it relates to protecting student rights. So I want to kind of just talk about the three things that, when taken together, are really what help protect our undocumented students. So Plyler v. Doe, as I mentioned, a 1982 Supreme Court case explicitly states that a child cannot be denied equal access to public education due to their citizenship status, that children must be allowed to attend public schools K-12 without limitation or discrimination. It's important to understand, however, that in recent years we have seen state legislative efforts attempt to chip away at this decision, and I'll give you some examples of that in a minute. Together with Plyler v. Doe, we have Title VI of the Civil Rights Act of 1964, which states that no institution receiving federal financial assistance may discriminate on the basis of race, color, or national origin. Okay, we talked earlier about discrimination on the basis of sex. Here we're talking about race, color, or national origin. Title VI also extends public schools, colleges, and universities. Okay, it's important to understand that Plyler v. Doe applies to K-12. Okay, but the Civil Rights Act, Title VI, goes through colleges and universities. Another important law here, which you watched a shorter lecture about, was FERPA. Okay, and FERPA, as you may recall, addresses parents and families' right to privacy regarding personal details. Right, it's the Federal Education Rights and Privacy Act. Okay. So through the Office of Civil Rights, that's a part of the U.S. Department of Education, they have noted that schools and districts should neither ask about nor is any student under any obligation to disclose information on their immigration status. Okay, and the reason for that asterisk is because in the recent year or so, under U.S. Secretary from the Department of Education, Betsy DeVos, this has been questionable. The funding that is afforded to the Office of Civil Rights through the U.S. Department of Education has lost significant funding. There have been questions as to how and whether Secretary DeVos understands Plyler v. Doe. I have posted a video clip where you can see her being questioned. It was actually just just a little over a year ago, May 22nd, 2018, when she testified before the United States House of Representatives, the House Education and Workforce Committee, and she was asked whether or not educators can potentially report a child to ICE, to Immigration and Customs Enforcement. And what Secretary DeVos said, as you can see in the clip if you choose to watch it, eventually, she said, I think that's a school decision. It's a local community decision. And it was a really important moment. This sent shockwaves all across the country in terms of people being very concerned that this sent a signal to schools that they had the right to override Plyler v. Doe. It also stands, alongside of, as I mentioned in the earlier section, of states trying to chip away at Plyler v. Doe. So while students can't explicitly be denied equal access to public education due to citizenship status, for example, some school districts were saying that students could not enroll if the parent could not produce a legal driver's license. What does a person need to get a driver's license, right? So if you think about the ways in which, by extension, that discrimination was happening. We certainly were seeing kids dissuaded from being brought in. We were seeing unaccompanied minors from several states in the United States in recent years coming into the U.S., in particular like teenagers who were being deferred from and dissuaded from enrollment in K-12 schools to enroll in GED programs instead. Because schools felt ill-equipped to deal with the needs of these students and felt the students, quote, didn't know how to be students, and made some assumptions based on, where the students were coming from as to whether or not they had received a formal education of any type. And so they were either making it very hard for them to enroll in K-12, they were dissuading them from enrolling in K-12, and or told that they needed to go enroll in GED programs. So you've seen a variety of responses to this in the last couple of years. This is very real. This is definitely something that is impacting this very vulnerable group of students. It's important to understand that there are these protections in place, and when it comes down to it, Plyler v. Doe, Title VI, and FERPA are what protect our undocumented students. It is not a very firm law if you will. I mean, Plyler v. Doe is very clear as a Supreme Court decision, right? And as a Supreme Court decision, it applies to the entire country. But this is different than having a federal law in the books, for example, that states that education is a right for all students, regardless of immigration documentation, right, or whether or not a student is documented. And so, absent that, you start to see people, individuals, groups, districts, parents, etc., try to lobby, try to change, try to force and enforce these cracks in the system, of which there are multiple. And so, this is a very, very at-risk group of children and families. If you'd like to take a look at a letter that was signed by, it's something like 80 some odd groups of people who have called upon Secretary DeVos to clarify her decision or to clarify her statements. It's very important to see the ways in which people are fighting back and trying to protect this very vulnerable group of students. So I've posted a number of different resources for you on B-Courses, including information on this letter that I just mentioned, these 2 video clips, a brief and partial timeline of key policies relating to English language learning in U.S. public schools. These are just some of the many resources that are available to you on B-Courses. So thank you for your attention. I know I got into a lot of the wonky weeds, if you will, of public policy in this section, but there are a lot of very important things for us to do as social workers in this moment. And I will say that as soon as I hit stop on the recording of this particular lecture, things in public policy is always unfolding, is always changing. It's really important that we're paying attention and paying close attention to what's happening when we think about what it means to protect the rights of some of our most vulnerable students. Thanks for your attention, and I look forward to connecting with you in our next section.